Good morning, everyone, and a very warm welcome to South African Patent Law and Practice. It's one of the prescribed modules for the Patent Examination Board, as well as the South African Institute Intellectual Property Law, in order for practitioners to qualify as either patent attorneys or trademark practitioners. As I said, a very warm welcome to this module. I hope that you have an enjoyable time with me during our 2 days together as I present this workshop and exude and pass my knowledge of patent law onto you. So for those that don't know me, I'm Marco Vata. I'm a patent attorney and partner at the intellectual property law firm of Spur & Fisher based in our Centurion office. My contact details are available should you need to reach out to me, but you would have received my emails, hopefully. And on that note, I do apologize if you did not receive the study material prior to today. It appears that there was an issue with the firewall stripping my email due to some links in the attachments that were provided. So I will have a closer look at that and transmit that information and attachments to you during the course of this week. Please do accept my apologies for that. It wasn't something that I had anticipated to happen, but I did send through the presentation for today prior to our meeting this morning. So you should have it in your inbox this morning if you would like to download it and work through it with me today. So just some of my background, I have a BSc in microbiology as well as an LLB, obviously. And the department that I have oversight of is our foreign filing department, our agency department, as some might refer to it as. And it basically involves the filing of applications into South Africa that stem from abroad. And also advising clients specifically on the South African requirements. So I have an intricate knowledge of South African patent law and practice. It's what I deal with on a daily basis and advising clients from all over the world on the intricacies of South African patent law and practice. So a very warm welcome to you. Please do feel comfortable to ask any questions. If there are any attendees that are brave enough to turn their cameras on, I would really appreciate it. It just puts me at a bit more ease. I'm able to read your facial expressions. Thank you very much, Carl and Carl. Thank you, gentlemen. It just helps me to read the room a little bit, so to speak, and I do appreciate those of you that are willing to turn your cameras on, but don't feel obliged to. It just helps me with the whole process. If there are any questions as we go on, please do feel free to stop me at any time, but I do ask that you keep your microphones muted as we work through the slides together over the next 2 days. You'll see that I am recording the lecture, and this will be posted to YouTube within a week or two after our presentation, so you will have access to this again. But knowing that, please do still attend tomorrow, and please do engage as much as possible during the next 2 days. I have noticed that the participation and the students that do actively participate tend to do well during the exam. So it's not a case of just working through the study material on your own. It is important for you to participate and also to join the Q&A session. So closer to the exam date, I will arrange another 1 or 2 hour workshop or get a question and answer session for us, where we'll work through the last 2 years examination papers together. Not in too much detail, but just to afford you an opportunity to work through those papers together and to see what the questions are like and what is expected of you from the exams. Just to confirm, can everyone hear me fine? Can you see me fine? And can you see the slideshow fine? Perfect. I see the nods there.
Yes.
Thank you, everyone. Great. Thank you for that.
Thank you,
Okay,
Milka. Okay, Milka, it's
thanks,
Marie-Louise. So
Emil.
you will be recording, and yeah, I think there's one or two people still struggling to get in, but I've managed to send them the links. They've got Yahoo and some Gmail accounts which we battled to get through, but I'm attending to this. All right.
Thanks, Marie-Louise. I appreciate it.
Okay. Have a good day, everybody.
Thanks. Same to you. Bye-bye. So as you can see, the study material isn't really extensive. You do need to have a very in-depth understanding of the Patents Act and the regulations. The regulations, I don't expect too much detail from that. Where the regulation is important, it is highlighted in this presentation. And those are the regulations that I expect you to be familiar with. If you do feel that you require additional study material, the Dean and Dyer book is very helpful. It gives quite a broad overview of patent law. As you can see, it's this one that I'm holding up. So just a nice overview of patent law itself. And for those that are IP practitioners, it is a useful book to have. And I'm not saying that because it's Spurn Fisher that authored it, but it is just a general guide, a good guide to have handy on your desk. For more in-depth knowledge, you can always turn to Burrell's. This is the holy book for patent law in South Africa, authored by Tim Burrell, Dr. Tim Burrell. So if there is anything that you're unfamiliar with and you have some questions unanswered, you can hopefully get access to this book in your firms for those that are practicing in firms. I see that there's a hand raised for a question from Urshali. Go ahead.
Hi, Marco. How are you?
Well, in yourself.
I'm good. Wanted to ask, do you think the study material that you gave us is sufficient for the preparation of the exam, or do you recommend that we go through an external source like the Dean and Dyer book?
I don't believe it's necessary to use an external source. It's more for your own benefit. If you are unfamiliar with any of the concepts, the study material should be sufficient. But also attending this lecture, importantly also, is working through past examination papers and attending the Q&A session, which is very insightful. So that is one definitely to make sure that you attend. But the slides that I've sent through should be sufficient.
Okay, all right. Thanks,
Okay.
Sure.
Obviously, with the act together with that. Yeah. There were also some articles that I'd authored that I'd sent through with the presentation previously, but not this morning, because the issue with the transmission of those was in one of those articles. So I will resubmit those articles, which are also for your benefit to read through. And I have previously based some questions on the information provided on there. It was on relevant topics at the time. So do keep those in mind as well when preparing for the exams. Obviously not in too much detail, but just to familiarize yourself with what topics are relevant and of interest. In terms of the examination format, the exam is a 4-hour paper. The mark allocation ranges from 170 to 200 marks. It is a grueling exam. To sit for 4 hours to write is an incredibly long time, but this will also prepare you for the upcoming exams for the Group 2s as well, which are just as lengthy. So ensure that you are well rested for the exam, well prepared. The exam is not an easy exam. I can't reiterate that enough. Please don't take it lightly that because this is a Group 1 module, it is quite a difficult paper. So please do prepare well for it. It's not something that you're going to manage studying a day or two in advance. You will need to spend some time preparing for the exam. To give you an indication, the pass rate for the PEBs, or the average for the PEB students last year, was only 38%, whereas for SAIPL students it was slightly higher at 51%. So not great, and I hope that's not a reflection on my capabilities to lecture, but it does go to show that the standard is quite high. And also don't bank on past question papers only. I try not to repeat questions. It is very time consuming to prepare questions, but I do try my best to change it up every year. Okay, so don't just rely on those past question papers. Just to give you a format of how the day will go, I do tend to get a bit of a dry throat as I'm not this used to talking. I email all day, every day, and don't have many telephone calls. So my throat does dry up from time to time. So we will break every hour or so just for a quick comfort break, to have a sip of water or to snack on something. And then around 12 o'clock, we should break for about an hour's lunch. So you'll have ample time to get to some things that you need to, whether you want to have lunch or work through some emails. That's up to you. And then hopefully by between 3 and 4 o'clock, we should end off today. Tomorrow, I expect that we will end off a little bit earlier, but we'll see how the pace goes today and how much work we can manage to get through. As I said, please do feel free to stop me at any time if you require clarity on any of the concepts that I'm discussing. Or if you'd like me to repeat something, I'm very open to helping you. I want you to do the best that you can for this module, to create a good foundation for you as a practitioner in these group 1 and 2 modules that you're undertaking. Okay, with that, I wish you all the best. Please do engage as much as possible. It's incredibly boring for me to sit and listen to my own voice, so I would appreciate it if you do stop me and ask questions. Okay. So then moving on to what the agenda is for the next 2 days. I'll give a bit of a basic introduction into patent law and touch on IP law in general. Then we'll briefly look at some of the international arrangements that are in place relating to patent law. So the various treaties that regulate the cooperation between countries in relation to patent law. Then the most important probably for this module is the third item on the agenda, and that being the patentability requirements, where we'll look at Section 25 of the Patents Act in an extensive detail, looking at novelty, inventiveness, and what the requirements are for a valid patent to be granted. Then probably the most boring aspect is the procedure, and boring probably because this is what I deal with mostly on a daily basis. Is how do you actually apply for a patent application? What are the requirements to obtain a patent application? Bearing in mind that South Africa is a non-examining jurisdiction, we work on a depository system. So you file your application and the applications are only examined for their formal requirements. So are you in compliance with all the necessary paperwork? So we'll look at the procedure then and how to obtain a South African patent, granted patent, and also the various deadlines relating to when these documents are required, when acceptance takes place, when grant takes place, and also touch on some case law there, some interesting case law. Then we'll look at the corrections relating to the specification and claims of the patent application and the application itself, as well as the amendments to it and the requirements for the amendments to be made. Then at point 6, we'll look at the rights of the inventors, rights of the applicants, rights of the patentees, and what they can do with those patent rights. Then we'll touch on licensing, the restoration of a lapsed patent. So if the renewal fee of a patent was not paid timeously, what the requirements are to meet in order to have a patent restored by the registrar, or alternatively the commissioner, should it sit before the commissioner of patents. Then very importantly, the revocation proceedings, on what grounds a patent may be revoked, and briefly touching on the procedure regarding the revocation of a patent. We'll also touch on the infringement aspects relating to a patent. And then for self-study, will be 11 and 12. The appeals of any decisions taken by the registrar or the commissioner of patents, and also the penalties and offences of any of the offences that are provided for in the Act. Okay, so those will be for self-study 11 and 12. Okay, before we delve into the introduction, are there any questions that you might have on the study material, the examination format, or the setup for today and tomorrow? Pius, you have a question for us?
Hi, thank you, Marco. What do you mean by self-study? Would it mean not necessarily part of the exam, just something for additional resource?
So I can question on that, but I myself won't be working through that material on you. It's very self-explanatory from the slide. So that material is still provided for in the presentation today, but I don't necessarily go through that material with you. So it does still form part of the study material.
Thank you.
Pleasure. Are there any further questions? Okay, if not, then let's delve into it. I hope you already got your thinking caps on, have a cup of coffee to keep you going. So where do patent laws come from? What is the origin of patent law? And as a person having Italian heritage, I'm very proud to say that it stemmed from Italy in 1416. In 1416, there was the first known form of a patent right being granted. And this was by the what was known at the time as the Great Council of Venice, which awarded the first patent right for a technological invention to Sir Franciscus Petri of Rhodes. And this was in respect of a device for transforming wool into felt. And if you can transport yourself back to that era, the Renaissance era in Italy at the time, particularly in Venice, Venice was quite an important hub in Europe at the time, an important trading post from Italy, the rest of Europe, linking Asia. And this is where this need arose for some protection of innovative creations that were developed by people, to protect them and to provide a limited monopoly. So that was in 1416 where the first known form of a patent was awarded. Then in 1421 was the second known form of a patent that was granted, again in Venice, and this was for a novel boat design that was used to transport the marble slabs throughout the canals of Venice. And I mean, if you have ever been fortunate enough to visit Venice, you can think about a lot of the architecture, the cathedrals, churches, buildings. An incredible amount of marble was used at that time for the construction and beautification and ornamentation of these buildings. And that was to Filippo Brunelleschi, where this patent right was granted. But the first form, the codified form, where we actually have statutes that regulated the patent rights, was the Statutes of Industrial Brevets, which was codified in 1474. And as I've mentioned, this was the earliest codified patent system in the world. There's also known rights granted in England around that time as well for recipes, for instance, to chefs. But if we have a look then, what's very interesting about this extract that is from the Statutes of Industrial Brevets is that it mentions that each person who will make in the city new ingenious contrivance not made hereto in our dominion, as soon as it is reduced to perfection, so that it can be used and exercised shall give notice, it being forbidden to any other to make any other contrivance in the form or resemblance thereof without the consent and license of the author of up to 10 years, who shall infringe be forced to pay him the sum of 100 ducats and the contrivance immediately destroyed. And now, even though I've regurgitated that word, what I find incredibly interesting about this extract is that it is still so relevant to the patent law that we have today and so synonymous with Section 25 of the South African Patents Act. The reason being is that it provides for the novelty requirement that an invention must be new, which is similar to Section 25 of our Act that requires that an invention must be novel. And it says not made hereto in our dominion. So it's saying that this is a territorial right, that this novelty existed requirement was only extended to that region itself, and that it must have utility. So also one of the requirements of Section 25(1) that says that a patent or the invention must be capable of being used or applied in trade and industry and agriculture. So as you can see, a lot of similarities. Then it also provides for some remedies for the holder of this patent right. It's that any person that infringes, there is a remedy for the holder of that right to be granted compensation should there be any infringement of that right, as well as the destruction of any infringing articles. So very similar to the remedies that we would have today, where we can obtain damages or the destruction and delivery up of any infringing articles. And then also some provisions relating to the dealing of those rights, where you can license out that right. So it's an interesting one for me to see how not much in terms of the law or the crux of patent law has changed in 600 plus years. Carl, you have a question?
Yeah, it's just on the side. Would 100 ducats been a lot of money at the time?
Yes, I believe so. I can't quantify to today's money, but it would have been quite a lot. Yeah. And this is just an illustration of what that codified law looks like. If I just go back quickly, yeah. But why patents? Why obtain patent rights? And this is something that we will touch on in a bit more detail later on. But just to give you an indication of why not patent rights specifically, but intellectual property rights are so important in today's world, is that if you look at the S&P 500, which is an index used across the world basically to track the American stock markets, and it's the most commonly used index that's followed in equity indices, to look at the values of companies. And if we look back at 1975, we can see the 5 largest global companies by market share was IBM, ExxonMobil, Procter & Gamble, General Electric, and 3M. And at that time, the tangible assets, which are those in gray, of those companies exceeded the intangible assets. Now, intangible assets being predominantly intellectual property, as well as goodwill and reputation attached to those. But as time progressed and we've moved to a more digital era, you can see how there has been a shift in the value of those companies, where your intangible assets start to outweigh the tangible assets. And that's mostly notable, in 1995. And I mean, if you think about it, at that time, that's when computer technology probably became more prevalent. We started having personal computers in our own homes, and there was this shift in the value of these firms' assets from tangible assets to intangible assets, to where we are sitting around today's time, 2018, where the intangible assets far outweighs the value of the tangible assets of those companies. But what's also interesting to see is the type of companies that now sit at the top 5 of the S&P 500 and the type of technology that they deal with, where it is something that is more intangible, more digital. Those being Apple, Alphabet, Google itself, Microsoft, Amazon, and Facebook, Meta. Look, this is 2018, that although it doesn't seem so far away or so long ago, it's already moving on to 6 years. So it will be interesting to see what those stats look like now. If we consider what these intangible assets are, out of the 8 types of intangible assets that are identified when these companies are valued, 5 of those are all intellectual property related. So you can see why intellectual property is so important for these companies and why it is so important for us to ensure that those rights are protected, that vested rights are granted, and that you are able to quantify any intellectual property. This is merely just for information purposes, and what this image represents to me is the innovation that patent law brings and that patents themselves bring. Because in order for a patent right to be granted, you have to follow the quid pro quo principle, and that being that the applicant for a patent has to fully disclose what the invention is in return for that competitive or anti-competitive monopoly to be granted to the patentee. Because remember, patent rights are anti-competitive. You're excluding others in the market from dealing with that invention for a period of 20 years in South Africa. But for that limited monopoly, the proprietor of the invention has to fully disclose what that invention is. How does the invention work? What is the method that you would need to employ to allow for that invention to be created, to work that invention? What is the benefit of that, though? Does anyone want to give it a shot? What is the benefit of this disclosure of that patent right? Michael, go for it.
Good morning, Marco. I would probably
Morning.
say that it leads to continued innovation within industry. If we are disclosing and then you've got that limited monopoly right for 20 years, then after grant of a patent, you've got your competitors kind of relooking at and perhaps reconsidering where improvements could be made.
Exactly. That's precisely it. So by having that disclosure of what the invention is, it allows any third party, any member in the public to gain access to that document and to assess what developments can be made to that invention, what improvements can be made, and not just necessarily to getting to the final product, but possibly the method that's followed. What method can be changed? How can it be altered to be more efficient, more economical? And that's what the crux of patent law provides for, is that quid pro quo that drives innovation, that moves technology forward. And that's the prime example that I have up here. If you look at the Thomas Edison light bulb that was granted in 1880 in the United States to Thomas Edison, this is the first form of the light bulb, which is, although very basic today. You have a glass bulb in a vacuum with a filament passing through with a high conductive material. And when you pass electricity through it, it becomes incandescent. But from this disclosure, to the types of light bulbs that you see today, the LEDs, the technology in your monitor that you're looking at, the car's headlights, halogen, xenon lights, all of that, how the technology has developed from what was first disclosed in this patent document for the light bulb. Another fun example, who can identify that? I'm sure if you're a child and you stood on this, you'll know exactly what this was that inflicted a lot of pain in toddlers' feet and the parents, I'm sure.
Legos.
Okay, yeah, so this is the Lego brick, which was also patented in the US in 1961. So as most of you will know, a patent right only exists for 20 years. But do you think there's any other form of intellectual property that may still exist today that would protect this item in terms of intellectual property?
Trademarks for the
Yeah.
Lego.
Exactly, the trademark.
It doesn't every Lego brick still say Lego on it on each little bump?
So that would be for the brand itself, but for trademarks law specifically, a shape is protectable as a mark as well. So this shape itself is protected as a trademark, bearing in mind that a trademark's life can be to infinity, provided that the renewal fees are paid every 10 years. So yeah, trademark rights still exist over this Lego brick today. Another one that we can have a look at is the Gillette razor blade, something that's become incredibly expensive today for gentlemen to buy. I still go back to the old school one like this to shave my beard. It's just far more effective and cost effective as well for me personally. And then also looking at the first winged aircraft that took flight, that was granted to the Wright brothers in 1906. I see we have a hand raised up. Any questions?
I have a question regarding disclosure.
Yes.
Hi, Marco. I wanted to find out, when I was doing my master's, which pertained to the field of nanotech, I found that a lot of companies prefer to protect their R&D with trade as a trade secret rather than actually patenting their work. Do you find this to be the case often, or was it maybe more specific to that field that I found companies were not willing to actually disclose their R&D?
Yeah. Look, that does happen, and it is the case a lot of the times, especially with technology that's relatively new. And that is all dependent on the company's structure, and not just that, but also what value they can obtain for the patent rights. So just because I'm a patent attorney and I'm lecturing you on patent laws doesn't mean that I always advocate that the patent should be filed. And the reason being is that, your monopoly with the patent right is only for 20 years, whereas for a trade secret, you are able to monopolize that invention for a far greater period of time, provided that you can retain that disclosure in-house or that information in-house. So it all depends on, the company's needs. Look, I do like the benefit that there is a disclosure because it does aid the public in enhancing technology and developing further. But for commercial reasons, they would need to assess what is the most viable option for them commercially, whether it is to obtain patent rights or to leave it as a trade secret and to extend their monopoly for a longer period of time. But it is risky because if there is a disclosure and it's out in the public domain, they have no recourse.
Thank you very much.
Pleasure. Okay, so those are just some fun examples of patents that you can see were granted in history in the United States. But if we have a little bit of a closer look, magnify onto South Africa and what development South Africa has come up with, and something to be very proud of as South Africans are the inventions that were come up on our own home soil. The first one that's come up there is Pratley Putty, which was the world's first epoxy putty, which was invented by George Pratley in 1960. And the reason why it's sitting out there in space on the moon is because it was actually used on the Ranger spacecraft that went to the moon in the mid-1960s. Okay, so something very, very cool for South Africans. Then we have the Smart Lock syringe. And this was used by medical practitioners, and the need arose during the HIV pandemic to prevent the transmission of HIV when injecting patients that were positive for HIV, and to prevent that spread of the virus. So the smart lock was then invented in South Africa to assist with that pricking of the finger by mistake. Then another one that's very important to South Africa and to the economy in South Africa is the technology that Sasol deals with. The Q20 spray. I mean, if you own a house or ever have a squeaky door, this is something that you're probably quite familiar with. Q20 was invented in 1950 in Pinetown, actually in KZN, by Mr. Robertson. And he came up with this invention because the Volkswagen Beetle car was quite popular at the time, but it was also quite notorious for stalling in wet conditions. Now, if you can think in KZN, there's a lot of humidity in KZN. And this is basically a lubricant that then displaces water, but particularly at that time, that displaced water from distributor caps in the old Volkswagen Beetle, and would then prevent the stalling of the vehicle. So wherever there's a problem, there is some solution to be had, and that is where some of these great inventions arose from. So the Q20 and the smart lock being two prime examples there. Another one being the CAT scanner, which was developed by the Cape Town physicist Alan Cormack and his associate Godfrey Hounsfield. So technology that's used all across the world and incredibly important for medical diagnosing. The Dolos as well, which you may have seen along the coastlines of South Africa, which were used as breakers to prevent waves from eroding harbors and the walls along the coastal installations. And then another one being the creepy crawly. Okay. But there are also some very wacky inventions out there, like this one, the weird and not so wonderful, again going back to America, which was an anti-eating face mask. So for those that didn't want to take exercise or to change their diet, you could have this option of locking your mouth closed. I don't know if that was the greatest idea, but let's hope the keys were never lost for this invention if somebody were to use it. Okay, but basically an anti-eating face mask, mainly for those who are exposed to food constantly, such as chefs, cooks, restaurant personnel, or the like. So some wonderful and not so wonderful inventions out there that have been patented previously. But if you look at the nature of intellectual property rights, so looking more broadly again, IP intellectual property is something that is created by the human intellect, where there's some human endeavor, some work expended, some ingenuity and innovation of the creative efforts of the human mind, where intellectual property is created. So not just inventions, but brands, designs. These are all creatures of statute, so there is some law that regulates these rights. And very importantly is that these rights are territorial in nature. So there's no such thing as a worldwide patent or a worldwide trademark, but there are, however, mechanisms to assist the proprietors of these rights to obtain rights more globally. And the reason for these rights being territorial is that, countries are sovereign states, they have their own laws to follow, and the discretion is up to them whether those rights may be granted or not. So please, if anyone says they have a worldwide patent, it's absolutely bollocks. Okay, you need to apply for that right to be granted to you in every country where you feel that there is a possible infringement of the right should that technology be used in that country. These rights exist separately and independently of their creator. Michael, you have a question?
Hi, yes, sorry. I just wanted to find out, although probably not pertinent to this course, the validity period of 20 years on a patent, are there any exceptions to that globally?
So most countries allow for a 20-year period of the patent right, but there are some exceptions, particularly relating to pharmaceutical technologies. And the reason for that being is because pharmaceuticals are so highly regulated. So by the time that a patented pharmaceutical drug can actually enter into the market, there's a lot of market approval that needs to take place, a lot of clinical trials that need to take place, and approval from, the equivalent of the South African drug regulatory bodies or the health professional or medical councils before that drug can enter into the market. So that eats into a lot of the time of that monopoly before any profit, not just profit, but any sales can take place before that product can actually enter into the marketplace. So there are some supplementary patent certificates that can be granted in some countries where there is a pharmaceutical drug. Okay.
Sure. Thank you, Marco.
Okay. South Africa used to have that under the old act, but not in terms of our current law. And those are usually for a period of 5 years that those SPCs are granted.
Thanks.
Okay. And what's very important as well is when you are considering intellectual property, don't think of it as something that's completely foreign. I always try to bring it a bit closer to home. Refer to home. If you think of an asset that you have as a car or a house, you as an owner of a house or a car can deal with it in a way that you deem fit. So you are able to sell your house, if you've used it for enough time, you feel that you're not got any value for this house or you're looking to move, you're able to sell the house. And the same is applicable to patent and all forms of intellectual property, where you are able to deal with it as that asset and sell it to a third party in return for whatever value you expect from it. If we look at the example of a house again, you might not live in the house, but you have free rooms available and you decide that you rent your house out. So you are giving consent to a third party to live in your house. And that is the same as how a license basically works, is where you give consent to a third party to use that asset in accordance with what you have defined in your license agreement. So very important that IP rights are dealt with in the same way as tangible assets would, and that intangible assets can be dealt with in vice versa manner. Obviously, they are capable of being commercialized. I mean, why else obtain these rights? You want to gain some just benefit for the ingenuity and innovation that you have created. And these, again, are all creatures of law. Whether IP rights are immovable or movable, this was something that was touched on in the oil well case, where the courts actually found that IP rights are immovable property. I, for one, don't think that that is entirely correct. You can trade with these across boundaries outside of the borders of South Africa, permitted that certain exchange control requirements and that are complied with. There seems to be a slight delay on my side. Okay, so what is a patent? Maybe that's where we should have started off with. But a patent is basically that statutory monopoly right that is granted to the owner of the invention. Now, the owner of that invention can be various people, and we'll touch on that a little bit later on today. But the patent rights basically prevents others from exploiting the patentee's invention for a period of 20 years. And this is what we refer to as a negative right, because it's not giving you a positive right to commit an act. It excludes others from committing certain acts. What those acts are is set out in section 45(1) of the Act. So the patentee has the right to use the invention. The patentee has the right to exercise the invention. He has the right to import the invention. But as we've already mentioned, in return for the state, for the South African government to grant the patent right, the patentee must fully disclose that invention so that others may exploit it once the patent has expired. But also, as we said, very importantly for that disclosure is for the public to have the benefit of further developing and enhancing that technology that is part of that disclosure. So this last point basically referring to that quid pro quo, where the monopoly is conferred upon the patentee, and the quo being that new knowledge is presented to the public, as was stated in the Letrasat case, where they said that that disclosure must be presented to the public. So a patent is basically a vehicle for innovation. You know, it's something that belongs to the world of ideas and the world also in terms of commercial success, that of being money. Okay, so there is this duality of the patent system where it benefits not only the proprietor of the invention, but also the public at large. A lot of what we have touched on already is what is the purpose of a patent. I have spoken about this at length, and Michael also commented on what the purpose of a patent is. But just to touch on it briefly, it encourages improvements in technology and thereby drives innovation. It rewards the proprietor of that invention for those improvements in the technology or even the first creation of that technology. It allows for the disclosure of that improvement to the third parties, to the public at large. And it also encourages the application of the invention in society and permits for inventiveness to see how this technology can be further developed. It also acts as a deterrent to prevent infringers from seeking to unjustly infringe on those patent rights. So it protects against infringement by others and ultimately provides the proprietor with a prima facie right to defend those rights in court should an infringement ever take place. Okay. Edmund, I see that you mentioned that my line keeps breaking. Is anyone else having difficulties with my line?
No.
Not?
No.
Okay. Edmund,
good, Marcel.
No.
okay, thank you. I'd suggest maybe just having a look at the connection on your side then, please. Sorry, this shouldn't refer to US patent number on the top. This is actually a South African patent, and it's just to indicate to you what the patent certificate looks like once those patent rights are granted by the CIPC, the Companies and Intellectual Property Commission, which is the body of the Department of Trade and Industry and Commercialization. Okay, so patent, just to summarize then, is an exclusive right granted for an invention, which is a new method, product or apparatus, process or use that provides a new way of doing things or offers a new technical solution to a problem. Important to note is that for an invention to be considered an invention, it doesn't need to be a groundbreakingly new technology, provided that there is one aspect of that invention, or what we refer to as an integer, is new. It will provide you with novelty. So as long as ultimately one aspect of that totality of the invention has a new feature, that will provide you with the novelty required to obtain a patent right. Whether that integer is inventive or not is subject to a separate debate, and we'll look at that a little bit more closely. I think if you don't mind, we'll break for 10 minutes and then pick it up at 10:05 from the international arrangements section, the next section on our agenda. Are there any questions on the introduction that we went through before we break for 10 minutes?
Nothing from my side.
Okay.
I have one. Actually, I was hoping you could
Yes.
maybe clarify for me. When we spoke about the protection of the patent, you said that in some countries you would then need to make the application there. I'm just not familiar if then you would start the application process afresh, or you would just, yeah, I'm not really sure what the process
Okay.
is or what it entails.
No, that's fine, Lebo. I completely understand. If you don't mind, Lebo, could we put that one on hold, because we will touch on an entire section that deals with that process, how you would obtain those rights more globally. So not just in South Africa, but what the process is, looking at the different international arrangements in place. So we will go into that in quite an extensive amount of detail.
Okay, no, that's fine then.
Perfect. Thank you, everyone. I'll see you then at 10:05. Welcome back, everyone. We can then move on to the next section of today's workshop, where we'll look at the international arrangements. If you have any questions from the previous section, please let me know now. Then we can touch on it briefly before we move on to the next section. Okay, it doesn't seem that there are any questions. The section is quite limited because the international arrangements are dealt with to some extent in the other Group 1 and Group 2 modules. So this is merely for an overview and information purposes. And therefore, I don't delve into too much detail, but just so that you are familiar with the arrangements in place that relate to patent law that need to be considered. We will specifically look at the Patent Cooperative Treaty, which is an important one for patent practitioners and knowing the intricacies of what to expect from the PCT or Patent Cooperative Treaty. But the first treaty we'll be looking at, or international arrangement, is that of the Paris Convention. Now, the Paris Convention provides for three important aspects. The first one being the principle of priority rights. Now, the principle of priority rights permits an applicant for an invention and also for trademark rights, provides that applicants with an opportunity to file an application within a year from filing the first application in respect of that invention. So if we look at what I've set out in the slides, it says any person who has filed an application shall enjoy, for the purpose of filing corresponding applications in other countries, a right of priority for a certain period after the filing of the first application. So if an applicant has filed a South African application and they seek to obtain protection in other countries, it may file an application within 1 year from the date of it first being filed in South Africa in any one of the member countries of the Paris Convention. So a very important aspect that is set out and important requirement in terms of IP law is the principle of priority rights. So for patents, the term is a 1-year period from the date of filing your first application in respect of that invention to claim priority from that date in any other Paris Convention member country. It also provides for the principle of national treatment, which means that the member states to the Paris Convention must grant the same protection to nationals of contracting states that it grants to its own nationals. So there mustn't be any prejudice against any of the contracting states to the Paris Convention. So the same rights must be granted to applicants as it would to a foreign contracting state. And then it also provides for some common rules, which are just aimed at harmonizing the laws in various across intellectual property more globally, so that the laws are harmonized and to create a global framework for intellectual property law. Now, the Paris Convention is administered by WIPO, and South Africa became a party of the Paris Convention on the 1st of December in 1947. If we then look at TRIPS, or the trade-related aspects of intellectual property rights, again, TRIPS also provides for the minimum standards, which is similar to the principle of national treatment from the Paris Convention. I'm mixing this up. I'm referring to the national treatment over here at point 2, which again provides that it must accord protection to nationals of other member countries on the basis broadly corresponding to the principles contained in the conventions relating to intellectual property. So the general principle that there shouldn't be any prejudice or bias to members of TRIPS. But the minimum standards actually is analogous to the common rules of the Paris Convention, where it sets minimum standards for the protection and enforcement of intellectual property rights. So again, to harmonize the intellectual property rights on a more global scale. And then lastly, it provides for the most favored nation treatment, which requires member countries to adhere to the principle of non-discrimination as embodied in the requirements of the national treatment of the most favored nation treatment. So the most favored nation treatment means that where there is the most favored nation, if we can speak of it as such, those principles should be extended to all contracting parties. South Africa was a member of the WTO, who administers TRIPS, as I mentioned, since 1995 on the 1st of January. But prior to TRIPS, or the World Trade Organization, they were a member of GATT, which preceded the WTO since 13th of June 1948. But probably the most relevant international arrangement is that of the Patent Cooperation Treaty, or commonly referred to simply as the PCT. Now, what the PCT does is it provides for unified procedure for filing of patent applications in order to protect inventions in contracting states of the PCT. And I'll touch on this in greater detail as we move on. However, the PCT does not provide for global patent protection. Those rights still need to be nationalized in each country. So the PCT provides for a single filing process to take place internationally, and at a certain deadline, those applications still need to be nationalized in each of the contracting states where the applicant seeks to obtain patent rights. So, as I said, it doesn't grant international rights. It merely simplifies the process, and there are benefits to following the PCT route, which we'll touch on. So as you'll see at the second point there, the granting of the patent rights remains under the national or regional legislation of the national or regional patent offices, and that's what is referred to as the national phase. So the international phase follows the process of the application being filed at an international level. It undergoes examination at an international level, and then it needs to be nationalized in the respective contracting states. South Africa acceded to the PCT in December of 1998, and it was implemented on 16th of March 1999. So the PCT has an impact on foreign patents filed in South Africa and on the transfer of technology to the country, because it has made the process far more accessible in obtaining global rights by following the international phase of the PCT. There are currently 157 member states, and that is the most up-to-date stats on the number of countries that are party to the PCT. And this is administered once again by WIPO, as is the Paris Convention, as we mentioned. But in front of you is an overview of the process that takes place when following the PCT filing route to obtain patent rights on a more global scale. If an invention has been devised, you will file an international application with a receiving office, which can be the South African Patent Office or any other receiving office that permits applications from abroad, which is then filed with the international office. When you file that application, you will designate which country you wish to examine the application. And that is probably the greatest benefit of filing the PCT application, is that the international application undergoes a substantive examination. So the application is examined for its merits on whether it meets the patentability requirements of novelty, inventiveness, and applicability in industry, trade, or agriculture. So The International Searching Authority will then conduct this examination, which is one of the patent officers that you would have selected when filing the application that undertakes the search and examination of the application. And they will transmit to the applicant and to the International Bureau a search report and highlight in the search report whether they have found any prior art that might invalidate the validity of the patent. So if they have found that the invention lacks novelty or inventiveness or applicability in industry, and that is then set out in the search report that is issued to the applicant. So why is this such a beneficial route to follow? Is that before expending money in individual countries where you seek to obtain patent rights, you already have quite a clear indication as to whether your invention is novel, inventive, and applicable in industry or trade or agriculture. So before expending money in each of the various countries to obtain a patent right, you can decide in advance whether it is actually worthwhile pursuing patent rights for an invention which may not meet the patentability requirements in the various countries. But again, we'll look at this in a little bit more detail later on today when we touch on the procedure. But this is just a brief overview of the process that is followed. So once a search report is issued, the international application is also published online for the public to access. And then by the 30 or 31 month deadline, from the first filing of that application, you need to instruct that that application is filed in the various countries where you seek to obtain protection. And that's where you would enter the national phase. But again, don't be too stressed out about this yet. I know it's completely unfamiliar to many of you, but we'll look at this process in greater detail later on today. But just to keep this in mind as we move on. So as I said, what are the advantages of the PCT? Most importantly, you receive the patentability opinion before filing a national phase application in member countries. So the other approach that you can follow is to follow the Paris Convention approach, where you file directly into various countries. So you'll instruct your attorneys across the world within a 1-year period from when you first filed the application to file an application in that country. But you do not have any clear indication from an international body that has examined that application as to whether that invention actually meets the substantive aspects and requirements to fulfill the patentability requirements. So that is one great advantage that you have here, is to receive that patentability opinion quite far in advance of actually having to nationalize it and expend money on attorneys' fees, official fees to the governments to get those rights granted in the respective countries. So it does reduce your risk to some degree, because you'll have a clear indicator before filing across the world in various countries whether the invention is patentable or not. And that then can significantly reduce your prosecution costs. So whilst the PCT is an expensive process, as you can see the disadvantage that's set out here, it can save you a lot of money in the long run. If you were to follow the Paris Convention route, for example, where you don't have a clear indication as to the patentability of that invention, and end up having the application rejected by the examiners. I see that there is a hand raised from Alexia.
Hi, thanks. I wanted to find out, based on the fact that South Africa does not examine the subject matter of a patent, does that diminish the value of a South African patent in any way?
Not at all, because there is still the benefit of turning to the courts to assess. So the examination that takes place in South Africa would happen before the courts, where the court would assess whether the invention actually meets the patentability requirement. So there is a remedy to a patentee, or for the third party themselves, actually, should they find that there is an invalid patent on the register. So the register is obviously flooded with patents that are not enforceable or invalid, rather, based on not meeting the examination requirements, in terms of the substantive aspects. But the public does have the option to turn to the Court of the Commissioner of Patents to invalidate a patent.
Thank you.
Okay, then just briefly some other international arrangements. You have the European Patent Organization, which, similar to the PCT, you'll file a single application, but then designate the countries in Europe that are party to the European Patent Convention where you seek to obtain those patent rights. So in that instance, you wouldn't necessarily nationalize the application. You would designate the countries and pay the official fees depending on which countries you wish to obtain the granted rights for. Then you have a REPO, which is the African Regional Intellectual Property Organization, which is focused more on Africa, as well as OAPI, which is also a regional filing system, as with a REPO in Africa, but their territories are quite different. So if you have a look, the countries in black shown on the Africa map in front of you, those in black are for a REPO, and then OAPI being your more French-speaking countries. So these countries that are party to a REPO and OAPI normally have legal systems that are quite similar. So those in red were predominantly countries that were previously colonized by the French. So French-speaking countries having very similar legislative frameworks, and that's why those countries are therefore party to OAPI, because their legislation is quite similar. So with OAPI, it is very similar to the EPO filing system that is used, where you'll file one OAPI application and designate the countries where you seek to obtain granted rights. Whereas a REPO, on the other hand, is more similar to the PCT, where you file a single application and then still need to obtain national rights in each of those countries. Okay, as you can see, South Africa is not a member of either a REPO or OAPI. Again, a very economically important country in the African continent being Nigeria. Nigeria also not a member of those. Any questions on these international arrangements? As I said, don't be too worried about the PCT, because we will look at that in far greater detail when we get onto the procedure aspects of patent law. Okay, if not, then we'll move on to what is probably the most important aspect of this workshop, and that being the patentability of inventions. This section will ultimately comprise about 25 to 30% of the examination paper. So this is a very important section to be familiar with. Please do understand it. If you are struggling with it, I am always available to take your questions, to take your calls, to take your emails. So please don't feel shy to reach out to me if you are unsure of anything, so that we can work through this to the extent that you are able to apply it to the best of your abilities. Okay. So I'm jumping a slide, because if we look at section 25.1, section 25 overall in the Patents Act being very relevant to this entire section on patentability, section 25.1 says that a patent may be granted for any new invention which involves an inventive step and which is capable of being applied in trade or industry or agriculture. And that is basically the intrinsic requirement that an invention must meet. So, if we break down section 25.1 of the Patents Act, it provides that an invention must be an invention by its very definition. Now, the Patents Act, although there is a definition of an invention in the Patents Act, it simply states that it means an invention for which a patent may be granted under Section 25. And you'll see as we work through Section 25, practically anything can be considered an invention except for certain exclusions that we'll work through. So the invention must be an invention by definition in terms of Section 25. If not, it's not capable of meeting the patentability requirements and cannot obtain patent rights over that so said invention. Then, very importantly and most commonly, is that the invention must be novel. So the invention must be new. There must have been no existence of that invention at the time of filing the application. Then moving on to the next requirement is that the invention must involve an inventive step, and that is it must not have been obvious to somebody that is skilled in that particular technology. So it must involve an inventive step. That inventive step can be a move forward in technology. It could also be a sideward step. And when I say a sideward step, it could be a new way of approaching that invention, a new way, a new method to reaching a certain solution to a problem. Then the invention must be capable of being used or applied in trade or industry or agriculture. So I've basically just broken down Section 25(1) of the Patents Act into the individual requirements, and we'll touch on each one in a bit more detail as we go on. But as you can see from Section 25 and what I mentioned when we were looking at the first codified law from the Italian Renaissance in Venice, very analogous to the requirements there where it said any new contrivance that must be capable of being applied. The same can be said for in Section 25(1), is that it must be a new invention which involves an inventive step and capable of being applied in trade or industry or agriculture. And you'll hear I'm repeating this to you because you'll need to be able to wake up at the crack of dawn and be able to recite that section because it is so involved and underpins South African patent law. So in order for an invention to be patentable, it must meet the intrinsic and extrinsic requirements. And as I said, these are in Section 25 of the Patents Act. The invention must be patentable invention per se, as I said, so it must not form part of any of the exclusions that are provided for in Section 25. Does the Act define an invention? I said it does, although it's merely in relation to what the provisions of Section 25 provide for. So Section 25(2), 25(4), 25(11), and 36 do provide for some exclusions from patentability. So anything which does not form part of the list of exclusions is therefore capable of being deemed an invention, and that then meeting the intrinsic requirement for patentability, being that it is an invention by definition in terms of Section 25. So if we look more closely at these exclusions, the first being those in terms of Section 25(2). Section 25(2) provides that anything which consists of a discovery, a scientific theory, a mathematical method, a literary, dramatic, musical, or artistic work, or any aesthetic creation, a scheme, rule, or method for performing a mental act, playing a game, or doing business, a program for a computer, or the presentation of information shall not be an invention for the purposes of this Act. So quite an extensive list that's provided for in Section 25(2), that being an exhaustive list in terms of Section 25(2) of what is not considered a patentable invention. If we touch on each, a discovery is something that has already existed in nature. Intellectual property by its very nature is something that is created by human ingenuity. It requires creative thought on the part of the inventor. So discovery is something which has already existed in nature, and what nature has created cannot be invented. So therefore, a discovery cannot be considered an invention. There might be a compound, for instance, that has existed in nature, a chemical compound, and the method of extraction of that compound itself could very well be patentable. So you'll see the scope of protection is not towards the compound itself, but the method of processing that compound or the extraction of that compound, provided it is new and inventive, could very well be patentable. Then a scientific theory and a mathematical method. These are, again, logical explanations of aspects, again, of the natural world where a rule or a law is devised to explain that natural concept. So an example of a scientific theory being Newton's laws of motion or laws of thermodynamics or gravity. Mathematical method, again, a description of a system using mathematical concepts, such as the Pythagoras theorem. Then if we look at D, a literary, dramatic, musical, artistic work, or any other aesthetic creation, these are all forms of intellectual property for which there is sui generis law. Literary, dramatic, musical, or artistic work is provided for in terms of the Copyright Act. So this prevents the overlap between copyright and patent law. So those are all forms that are protectable in terms of copyright work, and so too for aesthetic creations in terms of either copyright or design law as well. So there is sui generis law for those provided for in subsection D. Then a scheme, a rule, method for performing a mental act, playing a game, or doing business. These are considered to be essentially mental steps or methods of applying one's mind. So such as an example would be the rules to Monopoly. There's no real human creativity or ingenuity involved in this, and therefore those provisions that are set out in E are excluded from patentability. A program for a computer, again, excluded from the definition of an invention, for the reason being that a computer program is again protectable under the Copyright Act, where that source code is protectable under the Copyright Act. However, with the development of technology, a lot of inventions require computer programs for their functioning. And in that instance, as a system where a computer program forms part of the greater scheme of the invention, there is probably some patentability that can be extended to that invention where a computer program is involved. And you'll see in one of the articles that I'll distribute to you that I authored, I look at the interplay between copyright law and patent law relating to computer programs, and what the European courts have found. This isn't something that has been adjudicated on before in South Africa, but Europe follows the approach that where there is a technical effect, so basically a solution to a problem where there is technology at play with a computer program, that is very likely to be patentable. Okay, so it's not for the source code as such, but overall the system that is patentable. Then the presentation of information, again, this is information that is presented in a readable form, and this is once more protectable under the Copyright Act and therefore excluded from the Patents Act. This slide basically is a breakdown of what we've just discussed, so I'm passing over that slide. If we consider those exclusions from section 25.2 of the Act, it's followed by section 25.3, which basically provides that the exclusions in section 25.2 must be narrowly interpreted. So you can't read into it, and it must relate to that item in the exclusions as such, so directly as it is stated there. So as I said with the computer program, yes, that exclusion is relating to a computer program. It is excluded from the requirements of what would be considered an invention, but that is a very narrow interpretation that must be applied. So where it is used in an overall system, it could be that it is saved by the grace of section 25.3 that says that the provisions of subsection 2 shall prevent only to the extent to which a patent or an application for a patent relates to that thing as such, anything from being treated as an invention for the purposes of this act. So if there is a claim in the patent specification directed solely to the source code, that will not be considered an invention because it is related to the thing as such, only that source code. But where that source code is in conjunction with other aspects in a system, then section 25.3 comes into play, and the interpretation that the European Patent Office has held, where if there is some technical effect, that it is deemed to be patentable. So as you can see, I did mention there's no case law on the interpretation of these exclusions in South Africa, but the boards of the appeal of the EPO did require that if there is a technical effect, so if the patent describes subject matter from the excluded category, in order to obtain a specific technical result, then a valid patent may be obtained. And that will always be in conjunction where it is used in a system. So where the source code in the computer program example is used in conjunction with certain hardware and other integers relating to that invention, then that should be patentable. Are there any questions in terms of section 25.2 or 25.3 regarding those exclusions?
Good morning, Marco. I just want to confirm, sorry, because this section generally just confuses me. The way that I kind of interpret it is that, let's say I had source code that was coding for, I don't know, a Photoshop program.
Yeah.
Does the patentability lie in the application to essentially, let's say, edit or format photos, not in the source code itself? So is the patentability linked more to the product of the program? So in theory,
yes. So what the solution
have...
is to the problem? Yeah.
Okay.
Yeah. No, that's entirely correct. So, and that's why section 25.3 expressly says as it relates to the exclusion as such. So it must be a very narrow interpretation to the source code only that is not patentable, but where it is used in conjunction to solve a problem to a solution, then it is likely to be considered patentable.
Okay, and then sorry, just a follow-up question. So if I then had completely different source code, but it still had the same effect, that would be grounds for infringement?
Look, that would then have to be reviewed under the Copyright Act, where the copyright would be the subject of the arguments that there is some infringement taking place. Yeah.
Okay, thank you.
Okay. Okay, if we look at some of the other exclusions of patentability, or what is not considered an invention for purposes of section 25, we'll turn to section 25.4 that provides that a patent shall not be granted for an invention, the publication or exploitation of which would generally be expected to encourage offensive or immoral behavior. So that's one of the exclusions. An invention with the publication or exploitation of that invention would generally be expected to encourage offensive or immoral behavior. Quite a gray area because it's very subjective. as to what would be generally expected to encourage offensive or immoral behavior. But an example that I could probably think of is a date rape drug, where a drug is solely manufactured for the purposes of inducing somebody into sleep for that horrible offense. Otherwise, stem cell related inventions are probably also against or considered immoral behavior. So those are just two examples that I can think of where an invention will be expected to encourage offensive or immoral behavior. Then if we look at 25(4) subsection B, for any variety of animal or plant or any essentially biological process for the production of animals or plants, not being a microbiological process or the product of such process. So quite a mouthful that's taking place here. But essentially, it's not possible to obtain a patent right for new breed of dog or new variety of a plant. The reason being why you can't obtain a patent under the Patents Act for a new variety of plant is once more because there is sui generis law in terms of the Plant Breeders' Rights Act, which provides for the protection of new variety of plants where there has been some genetic modification or crossbreeding or interbreeding of this variety of plant to create a new variety of plant. So that's the purpose as to why plants are excluded, or new variety of plants are excluded from patentability. Any variety of animals, once more, I think it just hones in on the point above where breeding of an animal is likely to encourage offensive or immoral behavior. Coral, you have a question?
Yes, just on is there any case law or anything around offensive or immoral behavior where there's an example of that, or there's nothing?
No, there's no case law on that. Sorry. And that's why I say it's very open to interpretation, and what some party other than myself might find offensive, they may not, and vice versa. But then it goes on further to say that not being a microbiological process or product of such a process. So yeah, section 25(4)B does provide that microbiological processes and their products are patentable. So the cultivation of a microorganism or its product to produce a useful product such as an antibiotic is itself patentable. So this exclusion relates to the cross-linking or crossbreeding of animals and plants. But it then goes in the positive to affirm that products of microorganisms and microorganisms themselves are indeed patentable. Just a note there to have a look at Regulation 28 uppercase A, which relates to the Budapest Treaty and the depositing of microorganisms. South Africa is a member of the Budapest Treaty. And what the Budapest Treaty provides is that when filing a patent application that relates to a microbiological organism, in order for any member of the one of the requirements is that an invention must have utility. It must be capable of being applied in trade or industry. And it's also a ground of revocation of the patent if the invention is not disclosed in a manner that it can be worked, then the patent can be revoked. So there has to be access to this deposit or to this microorganism. And the Budapest Treaty allows for this microorganism to be deposited either in cryopreservation at one of the institutes that permits or is a facility where this is permitted. You have to provide the documents relating to that deposit or the accession number of that deposit at one of these institutes in your patent application or in the specification itself, so that you fulfill the requirement that the patent can be worked. because without that microorganism, you won't be able to work the invention. Okay, so very important to note that where the invention itself relates to a microorganism or product of that organism, and there is a deposit that is required to work that invention, and for there to be sufficiency, and when I refer to sufficiency, it means that there must be a sufficient disclosure to somebody in this that's skilled in that technology to be able to work that invention. They must have access to what that microorganism is. So important to note those provisions that relate to the Budapest Treaty and those deposits of microorganisms. Then if we look at section 36, the Registrar of Patents may refuse. So this is not an absolute exclusion. It provides the registrar with the discretion to refuse a patent, which is contrary to well-established natural laws. And the prime example being that of a perpetual motion machine, where you have a constant supply of energy without any deterioration or input of external energy or deterioration of the output of that energy. That is contrary to natural laws of physics and thermodynamics and the like. Then again, the Registrar of Patents may refuse an invention sorry, I'm getting quite a odd sound on my side. Just bear with me for a moment, please. Just give me a thumbs up, or Carl. Can you hear me? Perfect.
Yeah.
Great. Sorry, I apologize for that. Okay, so as I said, again, this is to the discretion of the registrar whether she refuses or grants those rights. Again, an invention which would generally be expected to encourage offensive or immoral behavior. I'm not certain why the legislator drafted the act in such a way where in one breath it is completely an exclusion. If we go back in terms of section 25.4, sorry, everything's jumping around. You know, if we have a look for an invention, yeah, it says that a patent shall not be granted, but in the same breath in section 36, it provides that the registrar is authorized or has the discretion to grant or refuse. So a bit contradictory in terms of the act as to whether it should be granted or should not be granted. But then also inventions which may be used in any manner contrary to law. And an example that I can think of there is something that would be used in biochemical warfare. Just for your information as well, it's not something that I'll examine you on, is that there are additional requirements that relate to inventions that deal specifically with nuclear technology. If an invention relates to specific nuclear technology, then the provisions of Section 41 of the Nuclear Energy Act comes into play, where the Minister of Mineral Resources and Energy needs to be notified of that application for that invention that relates to that technology. And the Minister of Mineral Resources and Energy needs to consent to the further prosecution of that application in South Africa. So it falls outside of the realm of the Patent Office and then sits with the Department of Mineral Resources and Energy to first consider that invention and whether that invention will be contrary to the non-proliferation requirements relating to Nuclear Energy Act and provisions relating to international treaties in that regard. And this does happen quite often in practice. I myself deal with these quite often where an invention is related to nuclear energy. That application is then submitted to the Minister of Mineral Resources and Energy for his consideration. And once they have consented to the further prosecution, only then can the Patent Office accept the application for the patent. Carl, questions?
Yes, just coming back to the inventions that may be used in any manner contrary to law. I mean, that is a bit wide. I mean, almost anything can be used so one way or another against the law. So I mean, is it really? I'm just difficult to understand exactly where and when it would be applied.
Yeah, I think it's where the intent of that invention is specifically to create harm or to be contrary to law. So where the sole purpose of that invention is to be contrary or to be used for purposes that would otherwise be contrary to law, then it would fall in that ambit. But again, it's like you said, it is quite a wide provision, but that discretion again does sit with the Registrar of Patents whether to allow that application or not. I'm not aware of any that have actually been refused prior.
Thank you.
Yeah, but I think that is the test that the registrar would probably apply is the intent of this invention solely for use in something that would be contrary to law. Okay, I'm going to then turn to section 2511, which is another provision under section 25 of the Patents Act that has an exclusion from patentability or being excluded as an invention. This is a very important section, and this arises a lot in practice for those that are practitioners, particularly those in the biochemical field or biotechnology, genetics, chemistry fields. This will arise quite often in practice. But section 2511 says that an invention of a method of treatment of the human or animal body by surgery or therapy or diagnosis practice on the human or animal body shall be deemed not to be capable of being used or applied in trade or industry or agriculture. So if we go through that again, because it is quite a mouthful, and as I said, a very important section for you to know, is that an invention of a method of treatment of the human or animal body by surgery or therapy or of diagnosis practiced on the human or animal body shall be deemed not to be capable of being used or applied in trade or industry or agriculture. So basically where an invention that relates to the method of treatment of a human or animal body, either by surgery or therapy or by diagnosis, is not considered to meet the utility requirements. It's not capable of being applied in trade or industry or agriculture. And the reason for that is because these are inventions that would hinder a medical practitioner or a veterinarian from exercising their duties and responsibilities to the public in terms of treating a patient, whether it be a human or an animal. And that's why section 2511 exists, is to permit medical and veterinarians from practicing their respective fields. And why I say this does arise a lot in practice in South Africa is because not all countries have this provision. So in the US, for instance, it is possible to obtain a patent for method of treatment. But as I said, in South Africa, it does not. So oftentimes an invention arises out of America where the claims are drafted focusing on a method of treatment. That application is correspondingly filed into South Africa with those method of treatment claims. But based on Section 2511, it's not permissible. So there are ways that this can be overcome, and that's by looking at the way in which the claims themselves are drafted. But we'll touch on that a bit more. But it is important to note that the compositions or compounds that are used in such methods of treatment are patentable. So a pharmaceutical compound would be patentable in the method of treating a patient. Okay, so just very important to keep Section 2511 in mind. However, you'll see there that I state that this applies to both first and second medical uses of a known compound or composition. But if we go to Section 2511 in a bit more detail, there has been one case in South Africa that touched on this section, that had a look at Section 2511 more closely, and that was the Elon Transdermal Limited versus Ciba-Geigy case. And in this case, the courts found that the first medical use of a known substance must be claimed in the for-use type claim. So the way that that claim would be drafted is that it is a substance or a compound X for use in the treatment of disease Y in a patient. However, the second medical use, so Section 25(9) that we'll touch on later on, does provide that where a compound is used for a second medical use, it is still patentable. So if the compound was first used for treating blood pressure, but it's later discovered that that same compound treats heart arrhythmia, then that new use is patentable in relation to that compound. And that's where I'm coming with the first and second medical use of a compound. So the Elon Transdermal case held that for the first medical use, so where it was used to treat blood pressure, the compound X for use in the treatment of a disease Y in a patient, it must be claimed in that format. However, where that compound is for a second medical use, you need to follow what is referred to as the Swiss type claim format, where it's the use of that compound. So you can see it's the same compound as for the first medical use, but in the manufacture of a medicament to treat Z. So the disease being different between the two. So the compound is the same, but the use of that compound is different. Okay, so they're treating two different diseases whilst the compound is the same. So that is the law as it stands in South Africa. But if we consider European law, which South African courts often find persuasive and follow, the European court has recently held that the Swiss type claim format is done away with completely. And I do agree with that approach, specifically because of Section 25(9) that we'll have a look at. But they provide that the for-use type claim format when drafting your claims in the patent specification must always be in the for-use type form, irrespective of where it's a first medical use or a second medical use. However, because the South African law and our courts recognize Swiss type claim formats, the best approach is to advise your clients to include both types of claims when it relates to a compound for a method of treatment. Okay. Coral, you had a question, or have I answered it?
Sort of. I was just wondering, that is exactly your example of said compound X is used for hypertension, and then you've also find that compound X can also be used for arrhythmia. So whereas the Swiss type claim, well, it says in the manufacturer of a medicament, because I mean, in this case, it would not necessarily be a different type of medicament or whatever. It would be exactly the same thing, but it can be used for two things. So I was wondering about, yeah.
No, exactly. And that's why I don't necessarily agree with this claim format, but that is what our courts have sanctioned us to use in South Africa when drafting these claims. And I don't actually know why they went this route. It was almost as if it was trying to overcome certain exclusions from patentability in the Patents Act. But if you look at Section 25.9, which we'll touch on, Section 25.9 expressly provides for the patentability of compounds where they are used in a second medical use. Okay, so I don't know why there was this need to have it in a different claimed format. But as you can see, the scope of this claim is directed to that compound itself, so compound X. And maybe that's the reasoning behind it, is that the first medical use of that compound is directed to a compound X for use. So the focus is more on what is that compound, whereas the second medical use is more focused on what the use of that compound is. Okay. So you can see the scope of the claims is slightly different as to where the monopoly exists. Okay, but why does this come about where we have first and second medical uses of known compounds? So these are just some examples that I thought of. You know, the first one being that the drug is initially developed for a particular purpose, and then later research finds that the drug is useful in another therapeutic area. And sorry, gentlemen, I'm going to expose you now, but Viagra being one of those drugs. Viagra was used as a blood pressure medication, but was also then very useful for erectile dysfunction. So that's where that one would come into play. It could also be that the drug failed for its first known use, but then new use results were shown in therapeutic treatment. But then sometimes also a compound for non-medical use is found effective for medical use, and that would be an example of marijuana. So again, just an example of the first and second medical use type claims. The example that I used here is salicylic acid, which, as you know, is extracted from cheese and is basically the foundation of aspirin. Is used in the treatment of headaches. But then we also know that it is used to thin blood. So the second use of that drug was then the use of salicylic acid in the manufacture of medicament for the treatment of hypercoagulability. Okay, so just some examples. So do be aware as to what the South African court's current standing is, where a compound has a first and second medical use, as was found in the Elon transdermal case. Okay, but I do think that if the courts were ever to look upon a matter where such claims are in question, they will probably follow the European approach now, and that is that both should be claimed in the full use type format. And that brings us to the end of all the exclusions from patentability and what is not considered an invention in terms of Section 25.2 of the Act. Lisha, you've got a question?
Hi, Marco. So what happens if a second use develops way after?
So it doesn't matter when that happens. You will still meet the novelty requirement, provided that there was no disclosure of what that specific use was that you're now claiming in your patent application. So
Okay.
it will still meet, if that use is new, it doesn't matter when that arises.
Okay.
Yeah. Okay, so we've looked at the intrinsic requirements. Oh, sorry. Pius, you have another question?
So what you're saying in the second one, if it's used to treat another disease, but it's still the same compound, it qualifies for second use, second medical
That's correct, yes.
use. All right, so
That's
it does
right.
not necessarily have to be a new manufacturing.
No, it will be the same compound, can even be manufactured the same way. The novelty stems from the use of that compound. So what disease you're
For a
using to
different
treat.
disease.
Yeah. Are there any other questions before we turn to the extrinsic requirements? Okay, so we've looked at the intrinsic requirements. So basically what is considered an invention and the exclusions relating to an invention. So we touched on a discovery, a mathematical method, a scientific theory, computer programs, the method of treatment, and some inventions that are considered contrary to natural laws, offensive and immoral inventions. Just a hint, when you are answering your questions in the exams, although the provisions in the Act are incredibly long and worded, they do have very specific meanings. So if you look at section 2511, it's a method of treatment of the human or animal body. So it doesn't just apply to humans, it applies to animals as well. And it's by surgery or therapy or of diagnosis. And when you are in practice, you'll see that there are differences amongst each of these. And these are the ordinary dictionary definitions that are applied to these words. So marks are awarded for specific mention of what section 2511 relates to. So you will be penalized if you refer only to the method of treatment of humans by surgery, because you're only giving me less than half of what section 2511 provides for. So please do bear that in mind and break these sections down into the specific requirements. So if you look at section 25.4, it's not only inventions that relate to offensive behavior, but also immoral behavior. Okay, so all having very specific definitions. And as patent attorneys, you'll know that the dictionary and the use of language is incredibly important in practice. So that's why it's expected from the exams as well, that you are able to identify everything that is relating to a specific section or provision of the Act. Okay, but then if we turn to extrinsic requirements, these are the legal standards that an invention must meet in order for it to be patentable. And this comes down to section 25(1), where again it says that a patent subject to the provisions of this section may be granted for any new invention which involves an inventive step and which is capable of being used or applied in trade or industry or agriculture. So that is our novelty requirement, that the invention must be new. I do use the word novelty and new interchangeably. They have the same meaning when applying it to patent law. Then the requirement of non-obviousness or inventiveness. Again, these words are used interchangeably in patent law. Non-obviousness meaning that the invention was not obvious to somebody skilled in that technology. So somebody that is an expert in that field of technology, it should not have been obvious to that person, or inventiveness. Then capable of being applied in trade or industry or agriculture. And as we now know from section 2511, a method of treatment of the human or animal body by surgery, diagnosis, or therapy is not capable of being applied in trade or industry or agriculture. So let's turn to novelty as the first point of the extrinsic requirements. So in order for an invention to meet the novelty requirements, the invention must be new immediately before its priority date. Now, what do I mean by the priority date? The priority date is the date of first filing of that application in respect of that invention. Okay. So the first application lodged at the patent office in respect of that invention is the priority date. So when the courts consider whether the invention is novel or inventive or industrially applicable, they will look to the subject matter that is available to the public prior to the filing date of that invention for that application for that invention. Okay, so an invention must be new immediately before its priority date. So anything which existed before the filing of that application is considered prior art. So it is matter that is available to the public and which can invalidate or render an invention to be not novel. So an invention is deemed to be new if it does not form part of the prior art immediately before the priority date of the invention. Okay, so everyone understands what we mean by the invention must be new, hopefully. Okay, so if we look more closely at section 25.5, it tells us what novelty is, and it's a reiteration of what I've just stated. It states that an invention shall be deemed to be new if it does not form part of the state of the art immediately before the priority date of that invention. And the state of the art is defined for us in section 25.6. It says that the state of the art shall comprise all matter. And this is whether it's a product, a process, information about anything relating to that invention or anything else which has been made available to the public. And the public definition is incredibly wide. It's a global standard that's applied. So it's not just the South African public, but anywhere in the world. And whether it's by written or oral description, by use of the invention or in any other way, is considered to be part of the state of the art. So any disclosure of any matter, whether it was written or in oral description or disclosure, is considered to form part of the prior art. So me presenting a lecture and a disclosure of that invention that I've applied for an application for will be considered prior art and potentially invalidates an application for a patent if the disclosure was prior to me filing an application. Coral, you have a question?
Yes, just on the definition of public, as you said, I mean, if you do a lecture to a lot of people, but what if I discuss it with one person to check something around this invention? Is that also then made public? So where's the line? If I discuss it with a colleague and whatever, and we did, I mean, it's still my patent, but I just bouncing some ideas of him. Is that then made public or not?
Look, there is a precept that disclosure, you know, in the development of that invention between colleagues would be considered an authorized disclosure amongst yourselves, where there is anonymity to that or protection over that disclosure. But it's something that would fall outside of the realm of the development of that invention, if I can put it like that. Okay. You know, you also need to be very careful if there is a disclosure to a colleague and they are providing input, and that input that they've provided forms part of the subject matter that you're disclosing, then that person has to be listed as an inventor as well, because they've contributed in some way to the subject matter of that disclosure. Okay. There's a hand from the unknown user.
Sorry, so I just have a quick question.
Yes.
With regards to necessary technical trials, in that we're testing an invention on a small group of people, how is that disclosure?
Yeah, so a reasonable technical trial is excluded from being considered a disclosure in terms of novelty. And we'll actually touch on that in a few slides on.
All right, thank you.
Perfect. Yeah, so I mean, the basic concept of patent law is that an invention must be new immediately before its priority date in order for it to be subject matter considered to be valid for the patent rights. So as I said, anything basically counts as prior art, as I said, an oral disclosure, lecture or presentation, where this is very prevalent in industry is from research institutes, so your CSIRs and the universities that, whose sole purpose is to conduct research and to develop technology. And also the rating systems that are applied to researchers via the NRF and global rankings. A lot of these researchers want to get their publications out in order to, get more funding to build a reputation in their global community as well, but without considering the implications of the disclosure of their publications. So very important when dealing with these types of inventors, that they are very aware of the implications of disclosing their inventions by publications or presentations at conferences, global conferences, that there is the threat that they may destroy the novelty relating to their invention. And it does happen in practice quite often. Luke, you have a question?
Yeah, thanks, Marco. My question just relates to the destruction of novelty. If that is done in an unlawful manner, is it a case of there's no actual remedy going forward in relation to patent law? The reason I'm asking that, if there's a disclosure that happens inside a company, but there's a contractual agreement that they're not supposed to pass that information on, if they were to do that, does that actually end the patentability aspect in terms of being totally novelty destroying?
No, it doesn't. And you'll see as we work through the presentation as well, we're going to touch on that exclusion as well from being a novelty destroying event. So where there's an unauthorized disclosure relating to that invention, it doesn't destroy the novelty of the invention, but there is a caveat that you need to file a patent application within a reasonable time from being aware that this disclosure took place. Okay.
Okay, thanks.
Yeah. So then again, written publications, books, magazines, television or radio programs, prior use, so where you've exercised that invention in the manufacture or in sale of an article of that invention, disclosure on a website, that will all be considered prior art. I think very relevant today is the disclosures on websites. I had a case not relating to patents, but the same principles applied, was for a a patch, almost similar to a Transact patch, but relating to a registered design. The client wanted to file a registered design for this patch that you would stick onto your body with some medicament incorporated in it with a slow release mechanism. And their concern was that a few weeks prior to them filing the application, that there was a disclosure on their website of the actual product. And the same happens with, large corporations. If you think of Apple, Ferrari, when the new Apple iPhone will be released, there is disclosure of those designs and inventions prior to the actual release date taking place, which could then destroy the novelty of the invention or the design itself. Okay, so something that does happen very often in practice is that there are these early disclosures on websites. Some of the times unauthorized, as in the Apple instance, but sometimes by the proprietor's own doing, where they published on their own website prematurely. So the disclosure must have been made available to the public. And as I said, the disclosure may be anywhere in the world. And the standard of novelty that we refer to in this instance is that there's an absolute novelty requirement. So there's no grace period in South Africa from the date of disclosure within which to file an application, as is the case in some countries. Some countries permit as with design law in South Africa, a grace period within which to file an application should there have been a disclosure. The same cannot be said for South African patents. There's no provision for a grace period within which to file should there have been a disclosure. But then touching on some of the exceptions from novelty destroying events, or what would otherwise destroy novelty, where we've had 2 items mentioned already for reasonable technical trials and also unauthorized disclosure. Those events are not considered to destroy the novelty of an invention, and you can still obtain valid patent protection in those instances. So I've broken this down for you in the slides to consider the exceptions to novelty. So the one instance is where that there has not been any disclosure, but that non-disclosure is considered a novelty destroying event. So where there's no disclosure, so something that's not in the public domain, but it is still destroying of the novelty. And the first one being in terms of section 25(7), where there's a prior patent application that was not available to the public at the time of its filing. So if we look at section 25(7), it says that the state of the art shall comprise all matter contained in an application open to public inspection for a patent, notwithstanding that that application was lodged at the patent office and became open to public inspection on or after the priority dates of the relevant invention. If that matter was contained in that application, both as lodged and as open to public inspection, and the priority date of that matter is earlier than that of that invention. So quite a mouthful to digest, but basically if there is an application lodged at the patent office in respect of the same invention, and at the time of filing that invention, it's not open to public inspection, and we'll discuss when an invention becomes open to public inspection later on application when it becomes open to public inspection for all public to have access to. So if you filed, let's say, a first application, and it's in respect of invention A, and another application is filed by another party also in respect of invention A. But at the time that this invention was filed, this invention was not yet open to public inspection. But at a later date, it does become open to public inspection. Then it will destroy the novelty of the later filed application. So if we break it down again, as I've set out in the slides there, if there are 2 co-pending applications at the South African Patent Office, the one with the earliest filed priority date is considered to be novelty destroying in respect of the second later filed application, even though it was not publicly available at the time the second application was filed. So I'm hoping everyone is following what I mean. Okay. Pius, you have a question?
So what you're saying is that the first one is the one that then succeeds. Is that correct?
That's correct. Yes. So it's the first to file approach that's followed. So that first invention will actually have the priority and will form part of the state of the art against the second filed application, even though at the time it wasn't yet publicly available. But there is the caveat that it must become publicly available. So if it's a provisional application that was never completed and never granted, then it would be as if that never existed, and the second filed application the first filed application will not then be considered prior art because there was no disclosure from that provisional application. Okay. Then one of the second exceptions to novelty where there hasn't been any disclosure, but it is still considered to be a novelty destroying event, is that an invention which is used secretly and on a commercial scale within South Africa shall be deemed to form part of the state of the art. So an invention which is used secretly and on a commercial scale within South Africa. So note that this is limited to secret and commercial use within South Africa only, shall be deemed to form part of the state of the art. And this relates to trade secrets. So trade secrets would be considered prior art against an invention. But remember, it is linked to South Africa only. So if there was secret and commercial use of this invention taking place abroad, it will not destroy the novelty. It has to be within the confines of South Africa's borders for it to be a novelty destroying occurrence. But then now in the inverse, where there is a disclosure of the invention, but that disclosure is not considered novelty destroying, we look at section 25.9, which I did touch on earlier when I was discussing the method of treatment of inventions. And this is where there is a second medical use. So it says that in the case of an invention consisting of a substance or composition for use in a method of treatment of the human or animal body by surgery or of therapy or of diagnosis, practice on the human or animal body, the fact that the substance or composition forms part of the state of the art immediately before the priority date of the invention shall not prevent a patent from being granted for the invention if the use of the substance or composition in any such method does not form part of the state of the art at that date. Okay, so again, quite a mouthful to digest. It seems to be a reiteration of section 25.11 that refers to a method of treatment, but it touches on the second medical use of a known compound, which we discussed at length. If you recall the Swiss type claim format that should be followed in this instance. So where a medical composition or compound or substance is already known, but the treatment or the use of that compound or substance in the treatment of a new use will not invalidate the novelty of that invention. So although that compound composition previously existed, the new use will provide the novelty relating to that invention. Okay. Then if we move on to the next exception, that is where there's prior knowledge or publication of the invention is excused. So section 26 deals with this exception to novelty, and it says that a patent shall not be invalid by reason only of the fact that that invention in respect of which the patent was granted or any part thereof was disclosed, used, or known prior to the priority date of the invention. If the patentee or his predecessor in title, so whoever owns the rights to the invention and the patent, proves that such knowledge was acquired or such disclosure was made without his or her knowledge or consent, and that the knowledge acquired or the matter disclosed or used was derived or obtained from him or her, and if he or she learns of the disclosure, use, or knowledge before the priority date of the invention, that he or she applied for and obtained protection for his or her invention with all reasonable diligence after learning of the disclosure, use, or knowledge. So this is in the instance that Luke gave as an example, where there is an unauthorized disclosure of that invention before the priority date of that application. So before that invention was filed and there was unauthorized use. So the proprietor of that invention never consented to the disclosure of that invention. The novelty won't be destroyed. But as you can see, and as I mentioned, there is the caveat that once you are aware of that disclosure, you must apply for an application for a patent with all reasonable diligence after learning of that disclosure. Again, subjective, what is reasonable diligence? And something that the courts would need to assess on a case-by-case basis. Luke, does that answer your question from earlier?
It does, yes. It's just
Okay.
also a secondary question where it says that whoever the predecessor in title is, or whoever the patentee is, has to prove. It's just a question of, I assume that would be then before the court. So in fact,
Yeah.
you should just file your patent immediately, or your patent application. And then
Yeah.
at that stage, upon proof at a later stage, that it has to be deemed unauthorized. You can't
Yes.
just make the allegation that it was.
No, and so this will fall outside of the ambit of the registrar who receives the application. So the registrar won't necessarily know of this disclosure and decide to allow it, because they don't conduct examination. So if there was a disclosure, it won't even cross their desk. But it would arise in instances where litigation on that patent occurs before the Commission of Patents, so in the patent court, and somebody wishes to invalidate the patent on the ground that it isn't novel, then as a defense, you could raise that that disclosure was unauthorized. But again, as you said, there is a requirement that you have to show that it was an unauthorized disclosure.
Okay, thanks.
Thanks. Then secondly, again, which we did touch on earlier, is that as a result of the invention being worked in the Republic by way of a reasonable technical trial or experiment by the applicant or patentee or the predecessor in title of the applicant or patentee. So again, a reasonable technical trial will not destroy the novelty of that invention. And I mean, this has to occur in many instances in order to determine, what the outcome of that invention is, what the advantages of that invention is, to give you supplementary data that can be used in the disclosure of the patent application. So a necessary exclusion in practice, definitely. Are there any questions regarding the exceptions to novelty? Coral, you have a question, yeah?
Yes, just in terms of a technical trial, that doesn't mean like you would do a soft launch to see whether or not there's a market for it.
No,
I assume
it's
that
solely
will
within the it's
it's a
solely within the
technical trial.
development. Yeah, it's in
Yeah.
the development of that invention. So technical trial, not to conduct market research and see is this something that's gonna, sell on the marketplace. No, it has to be a technical trial. Great. Okay, how would the courts go about, because it's the courts that will, in South Africa, that will determine whether an invention is novel or not, and that will arise when a third party brings revocation proceedings to invalidate the patent. The courts will then determine whether there is novelty or not. If one of the grounds on which the patent is attacked, or a ground of revocation that is brought before the court, is that the invention lacks novelty, then the courts will need to apply a test in order to determine whether that invention is novel or not. And this is what would happen in jurisdictions where an application is substantively examined. And as you now know, South Africa doesn't follow the substantive examination steps, and that is as of yet. Just for your own interest, the South African government is driving substantive examination in South Africa. So in 2018, they published the intellectual property policy document. And in the policy document, they stipulated that South Africa needs to implement substantive search and examination. So the onus will rest with the Patent Office to examine an application to determine whether an invention meets the patentability requirements of novelty, inventiveness, and applicability. And the Patent Office then took the steps of employing examiners, so people that are skilled in different technologies, being chemistry, biotechnology, mechanical type inventions, electronics, and they have undergone extensive training, not just in South Africa, but from patent offices across the world. So the South African Patent Office had an agreement in place expressly with the European Patent Office, because our laws are so closely linked and because the EPO's examination is of such a high standard, as well as with influences from the Japanese Patent Office and Chinese Patent Office, to train the examiners on examination in South Africa, so that by the time the legislation permits for us to substantively examine applications, that we are ready to do so. So all the theoretical training of the examiners has been completed, and they're now going through what is known as the experiential learning phase, where member firms that are partaking in this exercise are obtaining permission from their clients to have some of their applications examined. It's only as a mock trial, it's a non-binding examination. There are, however, some implications in certain countries that if an applicant is aware of certain prior art, that it must be disclosed to that patent office. So the problem lies in that whilst this experiential learning phase provides a non-binding search report and opinion, it can have impacts on prosecution in other countries, because a South African examiner might pick up on prior art that the applicant was unaware of, and which could derail their prosecution in other countries. So it is something to be mindful of, that South Africa is taking steps towards examination. It's also debatable whether the Act provides the Patent Office to substantively examine applications. My view is that it does. However, the regulations itself does not provide for any guidelines as to how examination will take place. But the Patents Act is being re-looked at. There has been a draft of a new Patents Act in the pipeline for quite some time, but it hasn't been circulated for public comment at all. So we wait with bated breath to see where South Africa goes with substantive examination, but it is definitely something that will take place in the hopefully near future. Okay, but it is unfortunately a lengthy process before we get to that stage. But as I said, there are some benefits to having a depository system like ours, where you just file an application, is that it's more cost effective, the grant of the patent is quicker, and that the burden rests with the court to determine whether a patent is invalidated or not. So benefits to both types of systems that are followed. But as I said, I've digressed. That's just to give you some background knowledge as to where South Africa is with examination. But for now, when looking at novelty, that rests solely with the Commission of Patents in the court, of the Commission of Patents. And the test that was set out is the one that is now followed, is from the Genty-Rucco versus Firestone case. It is an incredibly long judgment, so I don't expect you to read it or to understand too much of that case, but you do need to understand what the test is when determining whether an invention is novel. And the first is that the claims of the patent have to be construed. So a patent specification provides for a description that includes some background information. It might discuss what is the relevant technology in that prior art, might set out what some of the advantages and benefits of this new invention are. It will detail how the invention must be performed, what the methods are, what the results are. And then it is ended with a set of claims. And the claims are what define the scope of the invention. So the claims are what the court will look to and what defines the monopoly relating to that invention. And it is truly a skill to be able to draft claims in a good manner to provide your client with the best form of protection that's not too broad, where you invalidate the patent because you claim the moon and the stars, but you also don't want it to be too narrow so that you're limiting your client's protection, and finding loopholes for potential infringers to overcome. So when assessing novelty, the courts always look to the claims because that's what the rights are that are granted to you, what the scope of protection is. So the claims of the patent have to be construed. And how that is done is that the courts will look at the claim and they will break it down into its essential integers. So what is it in this claim that makes up the invention? So it's broken down basically into a shopping list of what forms that invention. Then they need to consider what is the prior art, and they will look at the prior art. What is what forms part of the prior art? And in order for something to be novelty destroying, it has to form part of one prior art object only. So it can only be one prior patent documents, can only be one prior scientific publication. You can't take various documents, prior art documents or prior art disclosures, and mosaic them as what we refer to, where you compile and try to find that this invention discloses that invention. It has to be a single prior art object that discloses the invention. So the courts will look at what the prior art is that is being used to invalidate the patent, and they will construe it. And basically, they just compare, is there a disclosure of what the invention discloses and what the prior art discloses? So are all the integers that are defined and described in the patent claim, are they present in the prior art? If they are present, then there is obviously a novelty destroying prior art that destroys the novelty relating to that invention. Okay, so it's basically a comparison of the claim with the prior art. And as I said, in order for it to be novelty destroying, the invention must be wholly described in a single prior art document. Coral, yes.
Would that be applicable to all the claims? So all the claims must have been form part of the prior art or has been disclosed in the prior art, or if one or two of your claims is not in the prior art, is novelty then still there or not?
So ordinarily, you should have one independent claim, which is the main claim, and that's normally your first claim, which is the broadest claim. And if that claim, the independent claim, is found to lack novelty, but there is a subsequent claim that is dependent on that first claim. So an extra integer, for instance, that's further defined later on, and it's dependent on that claim. The court will grant the patentee the opportunity to amend the patent before the court to introduce that novel integer into that claim to overcome the novelty destroying event. Okay. So South Africa follows a partial invalidity approach. So one claim's lack of novelty doesn't destroy the enforceability of the entire patent. So even when assessing damages, for instance, the court will look at which claims were valid at that time in assessing the damages awarded. And they also take other things into the account. Was the patentee aware that that claim wasn't novel? If they were aware of it, then it doesn't bode well for the patentee if they were aware that that claim wasn't novel. And the courts will penalize the patentee in that regard, so possibly award less damages. So they do consider the behavior of the patentee. So I think that does answer your question. Yeah. Pius, you have a question?
Sorry, Michael. Yeah, considering that your dependent claims relates to your independent claim, which is your first claim. So if your first claim is invalidated or the novelty is destroyed, would the other ones not naturally fall away?
That is a fair question, but you could have an integer in one of the further dependent claims that could very well be a novel integer. But if that dependent claim also lacks novelty, then it's the whole relation between those claims will be lacking novelty.
Okay, thank you.
Pleasure. Another thing that the courts will consider as well, which isn't listed on the slides here, but was held in a 2015 case, which was the Mark Sharp Dome case and Cipla Agrimed. They said that there must be an enabling disclosure. So the disclosure in the specification should be a disclosure in such a way that it enables a third party to actually perform that invention. But that brings us to the end of novelty then. Are there any questions regarding novelty before we proceed to inventiveness? But as you can see, when it comes to novelty, it's quite an objective test that's approach that's followed. It's either those integers exist in the prior art or they don't. So if they exist and all those integers are disclosed in the prior art document, then it will invalidate the novelty of that patent. And if we then move on to inventiveness, which is the second extrinsic requirement that an invention must meet in order for it to be patentable. Section 2510 defines what is inventiveness, and it says that an invention shall be deemed to involve an inventive step if it is not obvious to a person skilled in the art, having regard to any matter which forms immediately before the priority date of that invention, part of the state of the art by virtue of subsection 6. Okay, then we can leave the rest there. But as you can see, this is a very subjective requirement, whether an invention is inventive or not, because it is something that is not obvious to a person skilled in the art. So if an invention is considered to be obvious to somebody that is skilled in a particular technology which this invention relates to, then it will be considered to not be inventive. And this is why in litigation proceedings before the court, the parties will often bring in expert witnesses, so people that are skilled in a particular technology, to give their opinion and their expert evidence as to whether an invention is considered to be obvious or not. Their opinion is obviously not binding on the courts, but it does have persuasive effect on the Commissioner of Patents in his assessment of whether an invention is inventive or not. Bearing in mind that the Commissioner of Patents, it's a High Court judge that's appointed to hear the matter in the Court of the Commissioner of Patents, is not somebody that has any technical background. You might be lucky if they do, but it's very unlikely that that will happen. And it's the role of the expert witnesses to come in and to educate the court on what the technology relates to, and to persuade the court on whether an invention is inventive or not. But as I said, it's an incredibly subjective test that's applied. And because it's so subjective, this is often the ground that is used the most in revocation proceedings. So it's the ground of obviousness, which is the ground of revocation most frequently invoked in practice in attacks on the validity of patents. It's a ground regarding which, more than any other of the circumstances and facts surrounding a particular invention at that time, far outweighs those abstract principles and definitions from the courts and the disclosures in those inventions. So one that is often favored when revoking a patent. If when assessing novelty, for instance, it's not very clear that you are lacking novelty. So you may have novelty, but it could be argued that you don't have inventiveness. So again, another court case to consider. So previously we touched on the Genti-Rucco case, which was a test for novelty. There's then the Ensign-Bickford case versus AECI explosives and chemicals case, where the court set out the test when determining inventiveness. Apologies. So to determine whether there's inventiveness, the first step is, what is the inventive step said to be involved in the patent? So what is it that the patentee is arguing or bringing to the fore to state makes this invention inventive? So what is that step said to be involved in the patent that is supposedly rendering the invention inventive? Then the court needs to consider what the state of the art is again that relates to that specific step. And then they need to consider how that step goes beyond or differs from the state of the art. Again, this is where the court will get guidance from the expert witnesses in rendering their opinions on whether an invention is inventive or not. And then the court would need to determine whether taking that step would actually be obvious or not to a person skilled in the art. Unlike with the test for novelty, where you can't mosaic prior art documents, the other court can combine all forms of prior art. So they can mosaic prior art when considering inventiveness. So they will look at all technology relating to that invention and see, if I was to consider all of this technology, would it be obvious or not to a person skilled in that art? Are there any questions so far? Okay. I haven't lost anyone, I hope. Good. Yeah, then just briefly touching on capable of being applied or used in trade or industry or agriculture. This is the third extrinsic requirement. This is a question of fact again. It's not something that I've ever seen in practice where an invention wasn't found to have applicability in industry. So you can just read through these bullet points, but just going to the grounds of revocation, it is important that this applicability also relates to the description, the drawings and examples as a whole when considering whether an invention is capable of being applied. So if the application cannot be performed, then it lacks utility. So you must be able to perform that invention in order for it to lack utility. So I'm not going into any much detail here. It's really not something that is ever raised in practice. So I do want to play a clip from a movie for you, which is a movie, A Flash of Genius. And this is based on the true story of an inventor who had difficulties in his eyesight. And at the time that he was a driver of his car, the wiper blades of the vehicles only had a single motion, not the intermittent or different varying speeds that we have today in the types of cars that we have. So depending on the magnitude or severity of the rainfall, you can have an increased speed of the wiper blade or something a bit lower. And with the difficulties in his eyesight and the rain and this constant movement of the wiper blades affected his eyesight even more. And he had developed or created the invention that related to the variable speeds of the wiper blades of cars. And he had approached Ford Motor Companies in the US with his invention, and they basically implemented the technology in their cars without any remuneration to the inventor of that invention. So basically stole his idea and went ahead with implementing it into their cars. So this is a clip from that movie, and I hope you'll be able to hear it. Let's see. Via Teams. Carl, just give me a thumbs up if you can.
Did create anything new. Could you explain what you meant by that?
Yes.
Sorry, I've lost my Teams page now.
So I could hear something, but I couldn't see. I don't know if it's the same for
Okay.
others.
I think it should work now. I've shared with the audio of my computer. So let's give it one more try. If it doesn't work, then I'm going to ask for your forgiveness. Okay, let's try.
You might buy out of a catalog.
Technically, that's true, yes. But
No further questions.
Okay, so an interesting scene, and it illustrates the point that an invention doesn't have to overall be groundbreakingly new. It doesn't have to be, you know, the Apple i3 with complete touch screen, you know, a shift away from the old phones that we're used to, but that a rearrangement of things that have previously existed to solve a technical problem, and whether it's a technical solution, is very well patentable, provided that there is some aspect of that invention that is new. And the argument that they were making is that everything that formed part of this invention had previously existed, but it's the arrangement of all those parts together that has created something new. So I think a very good example illustrated from the Flash of Genius movie regarding inventions. And I think that will bring us to the end of this patentability section. As I said, an incredibly important section for examination purposes and also for practice. You know, there's a lot involved in section 25. It touched on the basis of patent law, giving us the extrinsic requirements of novelty, inventiveness, and applicability. It also provides for the exclusions from patentability, how those exclusions must be interpreted in terms of section 25, where they must have a narrow interpretation. You know, then considering the method of treatments, the second medical use of known compounds and compositions, and some of the other exclusions from patentability. So a lot to digest from that section. And as you can see, there is really a whole lot that can be examined on from section 25. So please do spend a lot of time working on that section. Pius, you have a question for me?
Thank you, Marco. How would you test for industrial applications? Say, for argument's sake, it's novel, it's inventive, but now the industrial application is not established. Would it be patentable?
If they can't establish that, then it won't be patentable. It's not something that our courts have ever considered, and there's also no guidelines in terms of the Act as to how that would be determined. But if there is some application of that technology in any of those industries where it will fulfill a use, then it should meet that requirement of being applicable.
Or would it be a yes or no answer from the inventor's perspective? Because then there's no test for it.
Yes, it would be. But I mean, the invention will stem from the inventor. So it won't be the inventor that argues that it's not applicable or not. It will be from a third party that's invalidating the patent that might argue that it's not applicable. Yeah.
I see. Thank you.
Okay, pleasure. Okay, and with that, I think we'll break until 1 o'clock for lunch. Thank you everyone for your participation this morning. I really do appreciate the time you've set aside. And then once we return, we'll continue on to the next section where we'll look at the procedure. As I said, it's not the most grueling part of the work or the most riveting, but it is very important to have a good understanding of how to actually go about obtaining these patent rights and the procedure to follow. Please do think of any questions during this lunch break and come back to me with them when we return. So I'll give you an opportunity before we start for any questions that you might have. But until then, enjoy your break. I'll see you at 1 o'clock.
Thanks.
Thank you, everyone. Good afternoon and welcome back, everyone. I think we can delve into the next section of the work, looking at the procedure of obtaining patent rights. I see that there are some attendees still joining the meeting, so I'll wait another few seconds before we carry on. But in the meantime, please let me know if there are any questions based on the work that we have covered this far.
Sorry, Marco.
Yes, Brandon.
Yes, I just want to ask, I think it may have already been canvassed, but when it comes to the priority date with filing of your patent application. So let's go with the example of, we went through the PCT application process where 158 countries, I think you mentioned, you file it, a single filing is done, and then each country will it'll have to be nationalized within each country.
That's right.
Let's say you were then to file in a different way. You would file through South Africa. You just file your one application in South Africa. You would still, if I'm not mistaken, you would still have that year's priority claim if you were to file in another country nationally.
That's right. So in terms of the Paris Convention, you've got that 12-month period.
Yes. And now let's just say once that period expires, does that mean that I am now no longer allowed to apply for that same patent in any other country, or I'm just not allowed to claim priority from my South African application?
So you won't be able to claim priority, but also if the South African application becomes public, so if you complete it in South Africa, then the priority of that application will be considered prior art. So it will destroy the novelty of any further applications in any other countries. So you'll only be restricted to your rights in South Africa. But if that application that you filed in South Africa is never completed and is never made publicly available, then you can refile the applications, basically.
Thank you so much, Marco.
Pleasure. Okay, thanks, Carl and Kyle, as well, for putting your cameras on. You seem to be the only two that got out of their pajamas today, apart from myself. If anyone else decided to change into something more appropriate, please do put your cameras on as well. But as I said, there's no obligation. It is nice to see the faces. As you can hear, my voice is already getting a bit croaky, so please do bear with me if I take a sip of water every now and then. So we'll move on to the procedural aspect, and the first part that we're going to look at is the filing of a complete patent application, and then I'll touch on the filing of a national phase application via the PCT route. In terms of filing a complete patent application, I'll look at it from a South African perspective and touch briefly on it from a Paris Convention perspective as well. These deadlines that I refer to in the next 2 slides or so are quite important. When you work through the past examination papers, you'll always see that there is a question